So thank you for joining me. My name is Jennifer Kirschenbaum, and we're going to go through today understanding and preparing for business of medicine and your first employment agreement. Before we get going, this is me, and I represent physicians in all areas of their practice and also in their personal life. And the reason why I am giving this talk today is because we do a lot of education through our firm, mostly with physicians that are out practicing, but I spend a good deal of my time with residents and fellows who are leaving training. We do placement of a couple of hundred doctors a year all across the country, and it's absolutely my pleasure to share with you my knowledge base on what I'm seeing across the board right now for physicians as you're leaving, and then also give you some tips on what you should be looking for as you seek that first opportunity. So the bad news is that just like the rest of society, there's been a substantial impact because of COVID-19, and practices themselves have been really diminished. So as you go in and you look at future employers and you're wondering what the marketplace is going to be like right now, the answer is with tremendous uncertainty. There's also going to be a very, very high cost of practice right now because of social distancing measures and the cost of additional PPE. Staffing is very hard to come by. Administrative staffers and medical assistants, a lot of them don't want to work. So as you're going in and you're interviewing, or if you already have a job and you have an employer who's looking to kind of renegotiate on you or push your start date off, I'm not surprised that is happening or that would be happening. Many of your potential employers, whether it's hospitals or private practices, have been at a diminished capacity for quite some time, and some of them have just been closed. And some may not even be able to open in full capacity yet. They may not be able to do elective procedures, and they may be at very low volume. So there's been a severe impact to revenue over the last several months. And just to give some context, today's presentation is being given on June 3rd. So we've had several months of slowdown. Where are we going to be on ramp up? I don't know. Many of you probably know that better than I do from a medical aspect, so I'm not going to comment on that. But for the time period that we're in right now, for somewhat of the foreseeable future, we do have to worry about decreased patient volume. There's a high employment cost. There's possibly going to be additional costs for insurance, marketing costs, changing strategy of practices. So just be mindful of this as you're interviewing, because your employers are going to want to try to connect with you on a human level, and for you to have an understanding of where some of their main pain points may be is a good place for you to start. Employee considerations for this year coming out of and into practice, there's going to have to be some level of flexibility for the factors that I just went over. You know, your employers that are potentially looking to hire you are really going to be very strapped. So we're going to talk about that, what that means for your compensation, and some things you can do to protect yourself as you go into your employer negotiations. And hopefully I can give you some helpful tips to be able to navigate that construct. So the first question is, where do you want to practice? Do you want to work in a hospital? Do you want to work in a private practice? Do you want it to be small? Do you want it large, single specialty, multi-specialty? It's hard to really know until you're in that situation, but from my perspective, the more that you can kind of figure out what you want at the start, the better position you're going to be in later. And that being said, most residents and fellows do not stay at their first job. The reason being because they kind of don't really know what they want. They take what they think is the best offer, and what constitutes a best offer for them in their mind changes. You know, you might think it's the best number, when in fact you realize a couple years from now it's actually the best commute, and that's going to be what's going to do it for you. So you have to try to really know yourself and evaluate where you want to be based on your prior experiences, and try to project in your future to choose the best option. And I would definitely encourage you to keep an open mind. I've had a lot of providers who think that they want to be in New York, they have to be in New York. I think that maybe right now you feel I have to be out of New York. Now is the time to get out, use the hiring opportunity to get out of New York. So, you know, you may have yourself reconsidered your position from where you were 6 months from now, and that's totally understandable. So keep an open mind and see what's out there, and don't just look for one opportunity. Try to look at several if you can and see how which one's going to play out to be the best fit for you on a longer term basis. As you're looking at practices, these are some areas that I'd like you to try to focus on and figuring out. So there's some basic things you're going to do when you have a practice in mind to go to. You are going to first go straight to Google and do some background checks on the office itself. Read the Yelp reviews, look up the individual doctors if you can, try to get a sense on who they are, what they're about, if there's any information out there. Make sure you go in with questions for any interview. Even in this day and age with COVID and social distancing, I would try to encourage you to please go on site for any interview that you're possibly going to have. You want to get a sense for the practice and get an understanding of if people are happy there or not. Go wait in the waiting room a couple of minutes before. Take a look around, see what kind of operation they're running. If you can, I would want to have you shadow for a session if you can to see what the practice is about in general. So really try to expose yourself on site. If there are any associates that are there around your same age range or even colleagues that have been there for a while, try to get access to them and see, similar that any employer is going to ask you for references. You should be speaking to the people that are on site to see if you can get a sense of what the practice is about and what their mentality is towards patient treatment. More and more, I've had, in particular, certain specialties comment to me in the last few years that residents coming out are trained very, very particular in how to treat pain or certain other areas, and the doctors that they're joining don't necessarily have the same or updated approach towards patient care. And that type of moral quandary can really pose a terrible problem for a young doctor that comes out into a position. So when you're asked, or during an interview process, do you have any questions? Ask how they approach patient care. Try to figure out, what your principles are, and are they going to match up with this practice, whether that's hospital-based or private practice-based, because everyone has different training, different background, and possibly different approaches. And if you're going to be pressured to treat in a way that you don't want, then that's not a place that you want to join. So you want to ask. Now, when you do come out, you're going to be the captain of your own ship. There's no hiding behind anyone. You're 100% responsible for your malpractice. And you're going to be responsible for your documentation. And we have to be really careful how your contract is worded to make sure that you do have some protections in case, in reality, you're not the person who's in charge of certain decision making. For instance, if there's going to be a billing team that's going to be doing claim scrubbing and possibly doing the coding on your services rendered, then in actuality, you're not going to have a lot of control about what goes out the door. So you shouldn't be responsible for any type of recoupment demand by a payer. That would be on the practice. And we want to make sure that there's legal language in your agreement to help you with that. Now, depending on who you're joining and your hours and your level of control, you might have a practice or employer try to frame you as an independent contractor. Now, that is not just who wants to pay taxes for what decision. That's a decision that is actually based in fact and elements of control. So if you do have someone offering you an independent contractor relationship, you need to run it by your lawyer, run it by your accountant, make sure that you understand what that designation means and carries with it, because it's not just a willy-nilly select whichever one you want to be. There are going to be implications to the designation of an independent contractor or employee. And normally it's a level of control and also facets. So if you're not setting your own schedule, they're helping set the schedule, you're treating their patients, you're using their supplies, typically, and you have benefits, typically you would be an employee. So if you have an employer trying to categorize you otherwise, you want to make sure you have that reviewed. Now, I've heard this question many times, but why do I actually need a contract? Is it because everyone else has to sign one? No. It's because you're in a very highly regulated industry, being a doctor. A lot of people want to know who you're getting paid by and for what and how much. And a contract is a very clean and easy way to show why there's money flowing from a practice through to you. It is required in a number of different scenarios I could explain, that you have to have a written contract in place to show why money is flowing towards a decider of care. You also, for yourself, want it so that way you have enforceable terms. If someone agreeing to give you something, and we want to make sure that that is enforced. So we sign a contract and we abide by the terms, which also means that your contract is there for you as a fail-safe. And if the employer is not living up to what the employer promised, the contract is going to be there for you to be able to enforce, whether it's a payment term or a schedule that's laid out that you don't want to take any more call, or you want to be able to honor your days off, and whatever it is, we want it in the agreement, and we want it to reflect what you've agreed to. Now, your compensation is not just your base salary. It's not just that first number that you're going to be getting that you think is all in. In my mind, compensation is your full package. It's going to include benefits. It's going to include a sign-on bonus, if any, a moving expense, your incentive comp bonus, if you have any. There's going to be a lot of different elements of compensation that make up the full thing. Now, with COVID in mind, as I said, we're going to come back to this. We're going to come back to it right now. What do we do if I thought I was going to be coming out and I was going to be making $250? That was the number. All my colleagues before me, I knew they were making that. And now all the jobs that I'm seeing are promising only, $125, $150 on top of that, a percentage compensation structure, because they just don't know what the next year is going to bring. Well, what I would say to you is, if this year's market is not following the norm, I understand that. But I would like to see you secure the norm, or what we'd have assumed would have been your standard compensation number, guaranteed, as soon as there is a restoration to somewhat normal, quote unquote normal. So if you have to be reasonable and compromise for the next couple of months, I personally am comfortable with that only if I can draft in for you fail-safes that you are going to be able to kick up to the normal level of what would have been fair market value. I'm not interested in your compensation level just falling into an abyss. However, I do not want you to miss a hiring season because you're holding out for a number that just may not come around this year. So I am concerned about that. But I do think there are a lot of different structures that you can put in place, whether it's going to be revenue-based metrics or volume. We can try to protect against that kind of cushion that the employer may be looking for during this immediate period. If you're looking to get hired for August even, or September 1, they may not be willing to pay what we would consider standard. Many of your colleagues who came out a year or two ago, 3, 5, doesn't matter how many years ago they came out, a lot of doctors went without pay. And doctors who never in their life would have thought that they would be on unemployment are collecting unemployment checks right now. It's really just I don't have the right words for it, but just an absolute wild time to be witnessing. So we do need a level of flexibility if the employer is demanding it, because I don't want you to miss out on the job. I don't want you to have to wait for the next hiring season or the next position that may or may not come along, because I don't know when exactly that's going to be. So we can build in fail-safes, and I'm comfortable with, I may be comfortable with some of those depending on the language and what we can fall back on. Now, your term and renewal, I only care about when you can get out and when your employer can get out, because that's how long your contract is. So if you have a 90-day termination without cause provision in your agreement, then that's how long your agreement is as far as I'm concerned. So if you're taking a position where they say, no, you're secure, but there's still a 90-day without cause, then you have a 90-day contract. So if you're moving for a position, I would like to see that they can't terminate you without cause for a period of time. Now, that may not be something that we can accomplish because they may say to you, well, we won't hire you unless you're going to give us 2 years. And I'm not going to tell you ever to take a job where you can't get out for 2 years. And they may say, well, if you want to be able to get out in 90 days, we have to be able to get out in 90 days too. That's reasonable. So, that's how those negotiations go. And a lot of these initial negotiations, you're going to be handling yourself. And we'll talk about that in a couple of minutes on who I think needs to handle which parts of the negotiation, because I think that that's really super strategic. And I feel very strongly that a lot of these initial points are better suited for you to be handling yourself. Now, I'm sorry, this slide's a little old. I should have replaced it many years ago. But are you interested in partnership? Now, this partnership track, this was correct when I first started practicing law, and I grabbed the wrong deck today. Most places are not offering a partnership track. They might be offering some sort of small equity piece if they're owned by private equity, which is pretty new to healthcare over the last couple of years. There's been that construct, and if any of you want to hear more about that, we could do a whole other talk about what's going on in medicine and how the market's changing and how the interests are changing there. But right now, a lot of places are not necessarily offering partnership. There may be a surgical center arrangement or buy-in for some of you, depending on your specialty. So there's different types of things. But what I would say is, don't worry about that right now, because no one in their right mind is going to offer you a defined partnership construct that you can sign on to right now and lock in before you started working for them. That's just not realistic. It's not going to happen. So what I'm more concerned about is, what does your offer look for right now, for this coming year, the year after? If you have to make a reasonable accommodation for the next 6 months, I am comfortable with that, so long as it is not going to impact you long term. Okay, so that's kind of where I stand on that. Now, location is really important, because whether you think about it now or not, commute time, quality of life time, this impacts everybody. So you're signing on to work at a particular location is what I would like. I do not want you to join a multi-office practice or group where you just can be sent willy-nilly to whatever location they want whenever they say. So I want you to have to consent to going to different locations. I want you to agree on a specific location. I want you to define where you're going to be working. I want you to clearly delineate in your agreement what your responsibilities are. So many contracts are going to have specific clinical allotted time, whether that's 35 or 40 hours a week. Now, if you're doing patient appointment hours for 30, 40 hours a week, when are you going to be doing your administrative work, right? Because there's a lot of documentation that goes along with the visits. So, and then on top of that, if you have call. So I want to be able to limit, or at least define very specifically, what your obligations are to the employer, and what is your time going to be comprised of. Approximately how much clinical care time, how much administrative time. Some of us can do that faster or slower than others, but approximately. And then your call should be limited. It should be, set days per week limit, days per weekend limit, federal holiday limit. It should be distributed equitably, not just equally, but equitably amongst similarly situated doctors. And you want all that laid out in your agreement if you can get it. Now, I can get to my comments about what I was thinking later, but credentialing and privileging. I do not want your employer to be able to stand on a condition precedent that you have to be credentialed or have privileges at a hospital before you can start, because oftentimes they take that process on for you, and if they make an administrative mistake on their end and you're banking on your salary starting on a specific date, you shouldn't have to be pushed off. So just be mindful of that as you go through your employment agreement. Malpractice insurance, there's 2 different types. And if we were in person today, which I'm sorry we're not, I would ask someone to tell me the difference if they know. But since we're not, I'm just going to explain it. An occurrence-based policy, which is available in most places, is the best coverage you can have for the entire policy period. It covers you for all events that occurred while the policy was in effect. Doesn't matter when the claim is made. So if you saw the patient while you had the policy, doesn't matter when the patient files a claim, which is a lawsuit against you, you would be covered. The claims made policy is less expensive premium, so it's cheaper, okay? And cheaper doesn't always mean not as good, but in this instance, that's exactly what it means. It's not as good. Claims made is cheaper, and it only covers you for claims that are made while the policy is in effect. So if you see the patient and the patient sues you after the policy period, you would not be covered. So the reason why practices would choose this is because it's cheaper, and they'll put in the agreement that for you to be really covered, no matter when the claim is filed, then you would have to purchase an extended reporting endorsement, or tail. And the tail can be very expensive. So they may be looking to get out of the obligation of providing you full coverage, and then having you step in and monetarily have to cover that. So when I look at your compensation, as I said, as a full package compensation, I look at all these things together. Like, okay, if you leave, how much is your tail possibly going to have to be? Because I have to build that into my brain on evaluating this offer for you, whether or not this is a good deal. So if the tail is in there, now there's accommodations we can make. Like, let's say you'll tell them, okay, if I tell you I'm going to stay for 2 years, but I leave within the first 2 years, then I'll pay the tail, okay? Or I'll deal with my malpractice insurance, meaning you'll pay the tail, or you'll pay with continuing it. Those are that's a negotiation point that we can have, and possibly they'll agree to some sort of limited or they'll agree to some sort of accommodation for you there. And I think that that's not unreasonable. So there's a couple of different things that we can discuss related to malpractice insurance and positions we can take that are reasonable. Now, termination, we talked about without cause briefly before. I'm really big on the ability for you to be able to leave and leave with a process and understand what you're entitled to when you leave. Everything you've earned up to the date that you leave, you should be able to keep. And if there's a bonus construct, we want to have clarity on how that's going to be paid out if you leave. That has to be built into your agreement. And there's been agreements that I've seen over the last couple of years where the employee does not have any ability to leave. By contract, they can't just without cause resign, which is insane because you can't force someone to work in this country. That's not how this country works. But it's very aggravating when you're trying to plan an exit if your contract is deficient and does not have that language in there. And you could have an unreasonable employer that actually does seek to try to force you to stay. And anytime you go to litigation in life, pretty much, you've somewhat already lost because you're going to have a tremendous amount of fees. And we'll talk about that with the non-compete, which is here. So restrictive covenants is a big thing. The restrictive covenants are encompassing of a non-compete and a non-solicit. The non-compete should say at the top of the restrictive covenant one, that should say non-compete. A non-compete restricts time frame and geographic range. So your contract is going to read under the non-compete, Steve, during the term of this agreement and for 2 years thereafter, you may not practice medicine within 2 miles of where you work. That is a non-compete. Now, Steve calls me and says, Jennifer, I signed this thing. I didn't show it to you before. What I didn't tell you was that my dad has a practice within that radius, and I want to go work there. I don't want to stay at this place. It's terrible. So I'm going to be 1.8 miles away as the bird flies within the radius. What do you think? I don't think they're going to sue me. What's going to happen? Well, I would say, okay, Steve, we should try to negotiate you out of this non-compete if you want to operate within the range. And if we can't get you out, then what's going to happen is the practice might first send you a letter, or they might just sue you, and they might claim that you are violating this contractual provision. They might give your dad a hard time for poaching you. They could sue him too. And you're going to have to pay a bunch of money to me or some other lawyer to put together a pile, not just a stack, but a pile of paperwork, because anytime you get involved with the court system, there's a pile of paperwork that's required, and it takes a long time to put it together, and it's very expensive. So you want to try to avoid that situation, because I get that question all the time of, well, it's probably not enforceable, right? Or non-competes aren't enforceable. At the end of the day, would a judge require you to not work at your dad's practice? Maybe, maybe not. Depends on what the compelling business interests are of the employer and what you signed in the language. And a judge might say you're enjoined from going to join your dad's practice. And if you did win, though, what would happen? Well, if you won, let's say, that means that a lawsuit was filed. We had to file an answer. We had to go through discovery. We had to file motions. So even if you win, you've already lost to a degree because you've had to pay a lot of legal fees. So to avoid on the back end, you need to plan to be preventative on the front end. As many of you who are listening counsel in your practice of medicine, preventative medicine will always, 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 at least from my understanding, be more cost effective and better for the patient than having to have that triple bypass on the back end. So it's the same thing in law. If we could just negotiate to a palatable non-compete or and a reasonable restriction on the way in, we're going to save a lot of heartache and aggravation on the way out. So leaving training, what to expect. And this is, I'm going to try to wrap up so that way I don't take your full lunch hour here. What to expect when you leave training, you're hopefully going to have a lot of opportunities and offers that you're going to look into. And you're hopefully going to do that in an organized and educated way. You're going to do your research on the front end. You're going to try to spend social time at the practice, even if you're not a social person. You need to put yourself out there and do what you can. Once you've negotiated some basic points like compensation, at least the start of that conversation with compensation, how many days off they might want to give you, if they're going to give you CME money, if there's going to be a moving stipend, is there a sign-on bonus, all these things that you may want to discuss yourself on the way in, and when would the offer start. You're then going to be expecting a contract. And these provisions that we went through today are going to be in there. Usually there's about 30 to 40 concepts that are covered in the standard associate contract. And those concepts are in there, whether I get a 4-page offer letter from a hospital plus a physician manual, or I get a 20-page contract from a private practice or a hospital. They could have a 20-page contract too. If the provisions that I'm looking for are not in the 4-pager from the hospital with the offer letter, they're likely going to be in the physician manual. So you need to get a copy of the physician manual. You have the power to negotiate. How do you win in negotiating? You have to approach your employer educated and consolidated. If you ask nicely, you will not lose your offer. Get all of your points together in an organized list and try to ask once if you can. So you're going to get the feedback from your healthcare lawyer. It has to be a healthcare lawyer, someone who has experience in the field, knows what they're talking about, deals with medical practices, knows what the industry standard is, and can assist you and provide you with that level of feedback, okay? You're going to get a full list of asks from that person, okay? And you're going to combine that with your considerations about why you think this is the right job. You're going to prioritize and make a list of top 5 or 10 things that you want to ask for, and then you're going to ask for them. If you don't get what you want, or you aren't effective, or if there's certain language that needs to be changed that is outside of your realm, at that point, that is when I would ask an attorney to come in and negotiate. But in the initial instance, I think it is incredibly important for those of you, all of you coming out. This is going to be for, well, I shouldn't say for all of you. Many of you have taken time off and whatever, but for a good portion of you, this is going to be your first professional job that you're negotiating for a real salary. You are going to be treated, as my slide said before, as the captain of your ship. You are in charge. The employer wants to see you stand on your own 2 feet. So to me, this is exactly what I said to my roommates from college. I have 2 friends from college that I lived with at different times. Both of them are pediatricians. And they both asked me to negotiate for them, and I told both of them that I would not. I did help them on the back end with the agreements, but I said on the first way in, you're a big girl now, you have to go and call yourself and go work through the points, because I felt that it was very important for them to be standing on their own 2 feet, number one. Number two, when I call for you, I have to speak to the lawyer. And the lawyer for the employer doesn't know you, hasn't met you, doesn't necessarily care if you take the job. So it's a lot easier for him or her to say no to me than it is for the chief of the department or your mentor or soon to be mentor to say no to you. So if they're asks that are related to your quality of life and to your compensation level, it has to come from you first. That's my feeling on it. Okay, so I'm trying to think what else I want to share with you before we sign off here. I do think that the market is going to come back, fairly quickly and strong. And I do not want you guys to feel like my comments today were to, scare you away from asking for things. I just think you might actually have to be a little bit more flexible on the way in, a couple of months more. Okay, so I have a question here. What is reasonable on non-competes? Do all offers have non-competes? The answer is that all offers, pretty much all offers that I've seen thousands over the years, have had some level of restrictive covenant, whether that is just a confidentiality provision, which says that everything that you have on site is confidential and you can't take any of the employer stuff. That's always in there. And it might only have a non-solicitation provision, which is a restrictive covenant. And a non-solicitation provision says that you can't take any of the employees and you can't take any of the patients. And that might be for a period of 1 or 2 years after you leave and during the time. Will every offer have a non-compete radius? I've seen certain offers come through, not many, where there's no non-compete. Now, the radius that might be in play for a non-compete that's reasonable, if you're in a metropolis like Manhattan, I would say, 5 to 10 blocks north and south, 3 to 4 avenues east-west is somewhat reasonable in Manhattan. Or you could do it by cab map. You could block out Soho or NoHo, or you could do it by area like that if you wanted to. I don't think anything much bigger than that. Depending on your specialty. If you're more of a generalist, and the broader the restriction, the less reasonable it is. If you are super, super, super specialized, and there's only 6 of you in the city, then they might restrict you from full hospital systems. They might try to restrict you from the whole island. So it really just depends on what the business interests are, on whether or not it's reasonable. Out in suburbia, of it after the fact. So if anyone has any additional questions, I'm happy to answer them. Oh, I do have some more questions here. Okay, let's see. Spend a couple more minutes. How about contracts tied to RVUs? Okay, we'll go through RVUs. I am seeing start dates being pushed off. The question was, do I see contracts being revoked now because of COVID, where they can't afford to hire? I've seen employers try to renegotiate compensation, and I've seen employers push off start dates. And the push off start dates bother me actually more than the renegotiated compensation, because that to me strikes a chord of less stability. RVU contracts are typically going to be given by hospitals. I like an RVU contract if there's a clear transparency in the reporting, because you're getting paid based on the services you're actually providing. So that's great. But you do want to make sure, and the devil's in the details with the language, because they could say it's RVUs, but then they could say they could also claw back based on how successful the employer is in their billing. And that's where you have to be really careful, because you do not want your numbers based on production to be subject to the success that the employer has in collecting. That is a factor that is going to possibly really change your ability to make money. So whether or not they're able to collect is not your problem if you're not in charge of the billing or coding. So I would be really careful with the language. Also, I'll warn you on RVU language, and this is general advice for when you're doing these types of negotiations. If you don't understand the English in your contract, that's because it probably doesn't make sense. So unless it's a very legal concept that you're just not familiar with and maybe you just need it explained. But all of these things that we're talking about here, you know, where you're working and what a restriction is going to be and whether or not you have a moving expense, which the average for that is not less than $10,000 if you're moving, you should be able to understand. If there's a recoupment amount in there, let's say you don't stay long enough, the job may say, if you don't stay for 2 years, I want the $10,000 back for the moving expense, or I want your sign-on bonus back. The language needs to be really clear. With the RVU language specifically, it's usually very complicated in how it's written, and there's a lot of defined terms, and it may not read properly. If you don't understand it, the reality is it may not make sense. So you may need to have that language reviewed, and you may also want to ask the employer for an example. How does this language play out? Can you explain it to me with numbers? Let's say that I generate $800,000 next year or $600,000 next year, and through these many services, how does that translate into what I'm going to be paid in your RVU construct? And you can ask them to please give you an example and work through with money. And a lot of times that's going to make it a little bit clearer, or it may complicate it more, and then you have to go back to look at the language. So anyway, I think that that's a good amount of information for today. And if anyone has any additional questions, I do a free newsletter usually twice a week. I've been a little lax during COVID. There's been a lot of other things going on. But you can send in questions. I'm happy to answer, and I'm happy to put you on the newsletter. And I wish all of you just great success. I want to thank all of you for the work that you've been doing the last couple of months. I'm truly appreciative. And if there's anything I can do to help you, you will let me know. We do have a flat rate for contract review for residents and fellows. We cap it at $500. That's just for the assessment and recommendations. If you need us to negotiate, we do that separate because we have no control over how long that's going to take. So thank you everyone for your time. I'll make this video available so you can listen to it and pull some points from it again if desired. And thank you.